Last matter to be heard before the court this morning is the case of Aliceson Humphries versus Lorain City School District. Each party will have 15 minutes in which to present their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know when you come up to the front podium. And I keep you track of the clock and we'll keep you apprised of the passage of time. Again, we are being visually and audibly recorded to be posted online, so please try to remain behind that front podium as much as possible. We have read your briefs and we're ready to proceed anymore. Would you like to reserve some time?
May it please the court, I'm Avery Freeman. I'm here on behalf of Aliceson Humphries. This is a case that involves a 700-page transcript, a 23-page opinion written by an appointed referee by the Ohio Department of Education who actually took all the lawyers on site to where this incident occurred in May of 2015, and also heard the testimony of 16 witnesses and about 50 exhibits. The hearing examiner made a determination, made findings of fact, and concluded that the school district's effort to end the employment relationship was excessive. In fact, what the record shows below, and again, it is a very heavily fact-specific case, was that there was a track meet on the 6th of May, 2015, and it involved a senior, Marley Mitchell, who was the nephew, or the niece of the plaintiff appellant. This was a very closely knit family, and Marley, the niece, was supposed to have been recognized at the senior assembly or senior event at the track meet. She chose not to do that. And what happened, and what the record reflects, which was not given due deference by the lower court, was that there was an altercation between the plaintiff's niece and the plaintiff's sister. And I must say that having had the opportunity to put witnesses on, to give the hearing examiner an opportunity to assess credibility, without that, the trial court could not have made a decision without looking at the record, and that's exactly what happened in this case. The school district, the appellee, claims that my client was engaged in conduct unbecoming, and it required a showing of provocation or committing an act of cruelty or engaging in a physical altercation. Well, at the trial of the case, what the hearing examiner heard was the testimony from the district of people, 4 of whom, 4 of the 8, never saw anything, and the other 4 had their vision obstructed, and none of the witnesses for the district heard what was going on.
Counsel, hang on, because I want to make sure that I'm understanding what you're telling me now and what I read in the brief. I did not get the impression from your brief, and please correct me if I'm wrong, that you were challenging the findings of the referee, but instead you're challenging the fact that the trial court failed to give deference to those findings. It sounds to me now like you might be challenging the findings of the referee. I mean, didn't the referee...
We challenge actually the ultimate conclusion that my client engaged in conduct unbecoming. We don't disagree with the findings. In fact...
Ultimate conclusion by whom?
By the hearing examiner.
Okay.
The lower court considered none of this. And the bottom line on it is, I represent an individual who spent 20 years of her life as an administrator, teacher and administrator, working with the most complicated, most vulnerable children in the Lorain School District. And whatever problems the school district had, its success included what Aliceson Humphries did as the CEO or the principal, essentially, of the Digital Academy. These were the children most at risk. What the hearing examiner did say is part of what the school district argued is there was an incident in 2009. But correctly, the hearing examiner said, look, that was mitigated. Number one, there was no finding. There was a letter of admonition for using profanity. But other than that, her work was exemplary. Now, the superintendent wouldn't concede that during cross-examination, but the hearing examiner did. And at the end of the day, what the hearing examiner saw were 6 witnesses who were on site. The district had an opportunity to do an investigation. They didn't. I did. I found a witness who testified, a student named Michaela Jones, who saw the whole thing. And basically, what the security guards representing the district saw was a fracas, but they couldn't get straight who the sister was and who the administrator was. And that's clear in the record and clear in the findings. That is something the lower court did not do. It is also significant that while the hearing examiner found that terminating her was inappropriate and excessive, what the district argues legally is a case, Speller, which affirmed the termination of an employee. But in Speller, the individual involved was guilty of a crime found by a court. In this case, there is no such finding. The police didn't investigate. Children's Services declined to investigate. There's been no determination by ODE. So what we found interesting was that we believe that the lower court ignored manifest weight of the evidence, failed to look at the record. We rely on Eastley, a Supreme Court decision, which interestingly enough relies on this court in the Tewerson decision, that the reviewing court weighs the evidence in all reasonable inferences, considering credibility, resolving conflicts. If not, there's a manifest miscarriage of justice. And so we believe that's exactly what happened here. 20 years of exemplary service. District employees getting mixed up in who was doing what, and who was in what car, and who was doing anything inappropriate. The worst that Aliceson Humphries did in this case below is after the matter was calmed down and she was going to the parking lot, she bopped her niece on the head for what she was doing. That was it. So we believe that the appropriate remedy here would be reversal and reinstatement, and we'd like to reserve a couple of minutes for rebuttal.
Did Ms. Humphries' sister testify?
The sister?
The sister?
Yes, the sister Natalie.
Yes.
When we showed the guard, for example, a picture of Allison, the guard thought, well, that was the person that hit Marley. That was the sister Natalie.
Did Natalie
Did
testify?
Natalie testify she grabbed her?
Natalie was the one, and
Yeah,
we...
that's not my question. My question is, did she testify?
Natalie?
In front of the referee?
Absolutely, in great detail. And that's what was the most telling. Very brash, as the hearing examiner put it. She was a woman of something like substantial physique. Clearly brash, admitted she used her fingernails, admitted she actually took her shoes off so she could get a better grip on the child, as opposed to my client, who, as the record shows, was the peacemaker here.
Thank you.
Anthony Giardini, I'm here on behalf of the Lorain City School District. And I think I'd like to start with what I think maybe is counsel's misunderstanding of how these administrative proceedings work and what the responsibility of the respective parties are. at least as I read this brief, I'm not sure the appellant understands that, because there's a statute, 3319.16, which protects administrators, this particular administrator had a 2-year limited contract that had been renewed over the years. The statute's designed to protect those administrators from just being terminated or have a contract terminated for no good reason. That there has to be good and just cause for it. It gives that the responsibility for making that determination to the elected Board of Education, 5 members, all elected by the residents of the district. And then it allows the Board of Education, if it wants, because they typically aren't lawyers, they're not very well paid, and as council mentioned, this was a 4-day hearing, it gives the Board of Education the option to appoint a referee to be a fact finder for them, to hear the evidence, to make rulings on objections and so forth. And that's what this board did. But the statute does not give away the board's ultimate duty and responsibility that they're elected to do to make a final determination as to whether or not good cause exists. The statute specifically says that the referee will make their findings if that's the option that's used, and it was in this case. The referee will make findings of fact, and then the referee will make a recommendation based on those findings of fact to the board as to what the referee thinks should be done. The referee is not elected, and the referee does not have the ultimate authority. The Board of Education retains that under the statute. So that, and the statute specifically says the board shall then either accept or reject the recommendation of the referee. Now, what the case law says, and this, the big case on this, is actually comes out of Lorain also. Frank Graziano, who I personally know, he was a teacher, went all the way up to the Supreme Court. The Supreme Court said the Board of Education, in making its determination, has to give due deference to the referee's findings of fact. In other words, you can't just ignore his findings of fact and then reject the referee's decision. You have to give it due deference. In this case, our Board of Education, when the matter was returned to them by the referee, to either accept or reject the referee's recommendation, absolutely gave due deference to the referee's findings of fact. Unfortunately, the referee didn't give due deference to his own findings of fact, because after he found as a matter of fact, and in his discussion, after he found that there was just cause, which is the whole purpose of him making a recommendation, it's the whole purpose of the statute. Was there just cause to take action against this administrator and terminate the contract? He then decides, well, yeah, there was just cause, but I think, the referee says, I think that it was excessive, and that while discipline is appropriate, and of course he doesn't say what the discipline then should be, but he thought termination was too much.
Doesn't the statute not allow for anything? I just gave you a double negative, I apologize.
Yeah, no,
Is the
it
only
does.
option under the statute termination?
Yes, that's essentially that's what we believe is the appropriate decision here. His decision is there just cause?
Are you
That's
saying
all
he's
we're
limited to that issue? Is there just cause or not?
I suppose I would say yes. If you read the statute strictly, he should either find that there's just cause or not just cause. And then based on that finding, either recommend termination or not recommend termination. But more importantly, the statute is very, very clear that the ultimate decision goes to the elected Board of Education. That I don't think there's any question about. Because otherwise, once the board sent it to the referee makes the referee's decision, the board should have been out of it then. It goes up to the court of common pleas if somebody wants to appeal it. But that's not what this statute, which specifically governs administrators in public education, says. This statute says it goes back to the board to either accept or reject. And then the case law says the board's action has to be upheld by the common police court unless the board's decision was contrary to law. Well, clearly it wasn't contrary to 3319.16 because the referee himself found that there was just cause here. And he simply then interjected his own viewpoint, which he has a right, I think he has a right to say termination's excessive. I don't think he has a right to say I find just cause, and therefore I'm not going to, in other words, what he should have found was there's not just cause to take action against, if that's how he felt.
Due deference doesn't require the board to go along with whatever the referee's recommendation.
That's exactly right, Your Honor. And the case law, and we cite in our brief several cases, including one out of Toledo, two out of the 6th District, clearly indicate that the board can, and in each of those cases, the referee recommended don't terminate. Each of those cases, the elected Board of Education says, now we're going to terminate, and they did so. What's before you now is a much narrower view of this whole thing. You have to decide whether the lower court, who did have the record, by the way, did look at the record, didn't just look at the referee's findings, but although he could have, the lower court could have just looked at this referee's findings, the things that the referee said the record clearly showed, and that would have been enough, in my view, to have affirmed the Board of Education's decision to terminate.
What was the board's vote?
The board's vote was 4-1 in favor of rejecting the recommendation of the referee. And at that point in time, then, I think the lower court had the law, I think is pretty clear on this. The lower court's review was the board's decision to reject the referee's recommendation against the manifest weight of the evidence. And Your Honor, this is probably one of the more egregious cases I've ever seen with respect to what the referee, same referee who made the recommendation not to terminate, specifically found. And I would call attention to this court's, to the referee's findings. And by the way, 4 of the witnesses who testified on behalf of the board, 2 of them were security guards who didn't have obstructive views. They were right there. One of them testified that they pulled our administrator off of one of our students. Pulled our administrator off of one of our students in front of everybody, other students, parents, other school staff, and then had to several times tell her to stop hitting our student. Several times, stop hitting the student. After the 6th command by a security officer who's appointed by the school district to maintain peace. So she was no peacemaker, she was actually hitting our student. After 6 orders to cease and desist, finally, she stopped. Once she stopped, another security officer started escorting this 5-foot student. She's 5 feet tall, 5 feet and slightly built, walking her to her car. And this administrator, the peacemaker, runs up behind the security officer and with an open hand slaps our student across the face. She was at that point in time being escorted by her arm by a security officer to the parking lot to her car. And our administrator goes up behind her and slaps her with an open hand across the face.
Face
Now,
or head?
pardon me?
Face or head?
Face. According to the referee, the finding by the referee was slapped her in the face. I think the administrator testified that she bopped her. So she admits to bopping her. She admits to pulling her hair. She admits to doing all these things. And if that's not conduct unbecoming an administrator, I don't know what is. And the 2009 incident isn't irrelevant. It is totally relevant because in that case, in public, in Cleveland by the Science Center in front of hundreds of students and parents. The same administrator grabbed a much smaller young man, about 12 years old, by the throat in a chokehold, something she admits, it's in the record, and then says, "I'm tired of your effing," and I won't use the words, it's not necessary, yeah, out loud to the student, "tired of your effing crap," while she is choking him. And it took another administrator from the district to pull her off the student. That was in 2009.
Of
And
course, that's probably not in this record.
it is in this record.
It is in this
actually.
record, okay.
It is, Your Honor, because we put it in the record and she was given 30 days off without pay, something she agreed to. She was subject to termination then, too. The board decided, and the superintendent decided to give her another chance. If she would go to anger management classes, if she would be psychologically evaluated. And obviously, fully expecting that we wouldn't have another such incident. And I was appalled by the referee's suggestion that because our student was her niece, that somehow justified or warranted or mitigated this whole circumstances. In my book, that makes it that much worse. That she would do this to her niece, knowing that her sister, and that's also in the record, knowing that her sister was a violent person, that she resolved issues that way. Why wasn't our administrator, if she was going to get into it, why wasn't she pulling her sister off of her niece, off of our student? All the testimony is that she grabbed her niece, that she grabbed our student, that she berated the student for pushing back against her mom, who was digging her nails into her, who was pulling her hair, and who was punching her. So if she's the peacemaker, why isn't she pulling her sister off of her niece, who's much smaller?
Did the referee indicate anything that would indicate that there was a misidentification by the security guard as to who the aggressor was?
No, Your Honor. And at the point in time that the four witnesses, one was a teacher and an assistant track coach. While she didn't know who Aliceson was and she didn't know who Natalie was, what she did know is that two women, and the only two women that were with Marley were Aliceson and her sister Natalie. The two women were punching, pulling the hair of, and slapping the student. She knew her student because she's an assistant track coach and Marley was on the track team. So the two adult women were punching, pulling hair, and grabbing at the student. That's what she testified to. So it didn't make any difference who she knew. And this gimmick at the hearing of showing a picture of Aliceson and asking the security guard a year later, is this Aliceson or is this Natalie, is irrelevant, because even Aliceson, Ms. Humphries, admits that she pulled her niece's hair. She admits that she grabbed her niece as opposed to grabbing her sister when they were at the fence. And she admits to, after pulling her hair and after being told to back off by a security officer, by two security officers, she admits that she then went up behind her niece and our student and slapped her. These are things that are all admitted, so it can't be a case of mistaken identification. She admits she did all three of these things. The referee made findings of fact on all three of these things, and it's more than supported by credible, independent, objective witnesses who had no axe to grind here.
What about the niece?
The niece
She identified who attacked her?
Yes, the niece identified both her mom as pulling her hair and attacking her, and the niece identified her aunt, Ms. Humphries, as pulling her hands off of the fence because she was clinging onto the fence because she didn't want to go out onto the field. She identified Ms. Humphries as the person who pulled her fingers off, while her mother, Natalie, is pulling her hair and punching her and doing all these horrible things that counsel described to you. And it just seems to me, if you're going to be the peacemaker, why drag the niece's fingers off. She's just trying to protect herself. Why not grab the other adult? And that would have been peacemaking from my town. Thank you very much.
Thank you. Attorney Friedman, you have 6 minutes left.
Thank you. I say this with great respect for my friend. Mr. Giardini was not counsel at this trial, he was a witness. And if you look at the transcript, the referee rejected a good portion of the testimony that was offered. That actually was part of the problem. The 2009 event was overridden, Mr. Giardini's recommendation, by the actual superintendent who actually brought her back and appointed her as an administrator. With respect to the characterization of what happened, it's inconsistent with what's in the transcript. The idea of representing this court that a security guard had an unobstructed view when the hearing examiner concluded that there were 20 people standing in between the security guard and the incident. The other thing is that the description of slapping her with her open hand is not part of the record. There is no such finding. The extraordinary thing about this case is the characters were on a central casting. The mother, Natalie, or Nana, as you'll see in the record, was this brash woman with long fingernails and high heels who testified that she took her shoes off to get a better grip on her daughter. And indeed, Jack Yannaris, who was a man in his 80s, who was 25 feet away, who heard everything and saw everything, characterized Aliceson as the one that went in there to break up the mess. So the characterization by the district and what's in the record are two completely different stories. That's what the district tried to argue, and that's exactly what the hearing examiner rejected. The fact is that the 2009 incident was mitigated according to the hearing examiner because the superintendent overrode Mr. Giardini's effort to get rid of her and brought her back. And ironically, think about this. After the 2009 incident, who gets appointed as the impartial investigator? Mr. Giardini. That's why he wasn't counsel, he was a witness. And that's why, among other things, when we tried to explain who this individual was, the last witness, and it was our expert witness, was Dr. Tracy McCarty. And Dr. McCarty was the superintendent of the Fremont schools, who explained not only that she knew Aliceson Humphries, and what an extraordinary administrator and devoted teacher she was, but then examining the facts of what happened here, she concluded that terminating Ms. Humphries for what the facts really were was inappropriate. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted to our website and that of Supreme Court. With that, the court is adjourned until Thursday in Lorain County.